Колеги, вітання. Ми продовжимо робочий день.
We'll talk about the perspectives of the law on civil service on a talk before the second parliamentary reading. And the speakers are Aliona Shkrum, MP of Ukraine fraction Batkiyvshchyna, Igor Koliushko, Brodsky, expert of new country, Civic platform, Valerii Pekar, new country, Mykola Vyhovsky, Reanimation package of reforms, Hilobok, advisor to the deputy head of the presidential administration of Ukraine. The floor is yours, colleagues. Hello, Aliona Shkrum, Batkiyvshchyna party. Thank you for gathering here. Yes, we did want to talk to you about a very important work that a lot of public organizations, experts, and government have done about the reform of civil service. As you know, we have adopted in the first reading the law on the reform of civil service. I do believe that this is going to be the first reform that will launch all the other reforms, and it will radically change our approaches to the work of civil servants and to their political stance and about them being not corrupt. I'm head of the working group on working out this topic for the second reading, and together with more than 50 participants, we held almost 30 official and 10 unofficial meetings with MPs, different factions, with representatives of state bodies to explain to them what is this law, what this law is about. And this law has got more than 1,300 amendments, and the amendments are still pouring in. Regrettably, we see that a lot of officials want to change this law to the level of it becoming unrecognizable, but our task was to secure the efficient and non-corrupt civil service and to remove the factors that could badly influence the civil servants and civil service. So there are two major factors that we want to retain: transparent, competitive selection for all the positions. For category A officials, this competition will be held by an independent Commission on Civil Service, where we will invite representatives from the Parliament and the Cabinet of Ministers and the administration of the President, and there will be 4 representatives from the public, and I think this is our first victory. To all other positions, open contests will as well be held, and there will be unlimited access for any citizen who would want to apply for civil service. All the vacancies will be on the single website of the National Civil Service Agency, as everyone will be able to see which jobs are vacant and take part in the competition. The second very important factor is the distribution of the delineation of offices for political and non-political, and even our constitution thus has a conflict of interests between different branches of power, and we want to make sure that political positions and political offices should not influence civil service, that should stay without any influence when the coalition or the government is changed. The civil service should be professional. These should be professionals who are really experts in their branches, spheres. They should not be dependent on political forces that come to power. Only in this way the state can be managed in a normal way, like it happens in business. We also wanted to concentrate on corruption risks that are present in the civil service at the moment, and make it not only professional and non-biased, but non-corrupt. It is important that the working group has worked out a rather good law that does retain all the principles that the public in Europe is expecting from us. We are obliged to adopt it as a coalition according to our coalition agreement and according to our association agreement with the European Union. For the first time today, this law will be tabled to the Committee on State Construction and Self-Government, and I want to ask for the support of all the experts and public and MPs and all the factions of the coalition, so that this law does launch a first reform, so that our civil service does become professional and independent of politicians. I hope that this law will build professional system of civil service and professional civil servants who will be guaranteed against any summary dismissal and against any influence of political views. The colossal work was done. It is important for us to support this law, to find votes for it, to explain why this is important, and to table it next week before the parliamentary vacations, and then we will be able to get this law within the next 2 months.
Good afternoon. During the time when we were working on this draft law, Aliona Shkrum has become such an expert that it's difficult to add anything. You've heard the main things already, but I will probably emphasize some of the details. Igor Koliushko, chairman of the board of the Center for Political and Legal Reforms, and I participated as an expert in drafting this law as part of the working group under the Cabinet of Ministers. The main positive features of this draft are: it ensures the competitive selection to all positions of civil servants. All the possibilities to manipulate appointments are removed. Also, there will be a standing body to defend the civil servants from political interference into their activities. It also separates clearly political and political appointments from purely civil servants. Until now, we still have some gaps where, if needed, the Cabinet of Ministers would always find a way how to avoid this principle of the separation of positions. Also, the law should ensure the stability of the civil service thanks to clear regulation of the issues of disciplinary responsibility, and it will be protecting the civil servants from subjectivism of their seniors in the process of their work. Also, I would like to mention that in the result of the work in Verkhovna Rada, as part of the working group, the draft was not worsened. We were very much afraid of that. At previous press conferences, we were mentioning that. But thanks to the work of a working group and the very skillful leadership of Aliona, it was even improved significantly. And it's much better now regulates the scope of the law itself. It more clearly defines the categories of positions, and finally all the MPs those who participated in the work, the experts, start understanding that category of position, it's not about some ranks. It also regulates the civil service as the public category. It is separated from labor law now, and it ensures better regulation of the powers of the Commission on the senior core of the civil service. And also, looking at the discussions that we had, there are still few issues which are still in the zone of risk. The pressure continues from some of the authorities. They say, include us into the law. I will not mention which authorities are these, but I would like to call upon all the MPs who will be voting for the law not to allow introducing into the law the names of the bodies. As a rule, it is easy to avoid such situation. Also, there are some proposals. They say, okay, let it be for everyone like it is in the law, but for us, for example, for the presidential administration, for example, just create a separate competition commission, and then we'll be happy. If everybody does that, then we will again ruin the legislation on civil service. And one more thing. We were surprised, many of the experts were surprised that an issue of politicization of civil servants was quite disputable. Both the experts and most of the civil servants that participate in the working group insist in prohibition of the participation of civil servants in political parties, because if there's no such a direct prohibition, then the leader gives, or the head gives an order to join this or that party by the whole department. If the head of the department changes, then the membership in the party is changing. That, on the one hand, does not correspond to the standards which European countries have, but they have never had such a problem. So we need to find a compromise that would protect civil servants from getting them involved into politics, and I hope that MPs will manage to do that in the result of passing the law in the second reading. Denis Brodsky, the expert of
the reanimation package of reforms, I'd like to continue with the topic of state civil servants being unbiased and politically uninvolved. We see that the law is rather difficult, and there are different views within the parliament, and we have quite a lot of apprehensions that the law won't be adopted in the way it should be. We do stress that state civil servants should abstain from serving political parties. You either serve the ideology or you serve the interests of citizens. We think that this is not going to be a limit on civil rights, but we think that every citizen should make a conscientious choice. Either they work for political parties or they work for the state, which means for the entire society. And although this law was worked upon by the Cabinet of Ministers, it does have a lot of influence from the public. And if people from the public who took part in working on this law out are in front of you, this law does create conditions under which state servants will serve, civil servants will serve the public. This is very important. You either serve the parties or you serve the people. At the moment, not all the factions understand how principled these positions and this stand is. Give us an opportunity to be sure that civil servants are for us, not for your political interests. We want to stress again, this law was not written by civil servants. We experts think that civil service can be adequate and efficient only when civil servants are well paid. There's a lot of amendments that change the system of payment for the salary, which makes them non-dependent on their next in line. They do not depend on bonuses paid by the directors. We also suggest that the salary of civil servants should be raised. We understand that at the moment we do not have money in the budget. We delayed this until 2017. But there's a norm here that will allow to survive until 2017, and because of the optimization of the processes of civil service, it will create conditions when there will be enough money to pay for the civil servants' work, and the state will be able to pay more money. We think that this is a very important clause, one of the conditions when the civil service will have an opportunity to change. As Aliona said, if there are no changes in civil service, there will be no changes in the country. Sergiy Soroka, expert at Civic platform New Country. We've been working for a year on this law. Before the press conference, Denis showed us a photo from the UCMC, which was taken a year ago. Where is the problem? And that time we talked almost exclusively about same things. This draft law was conceptually prepared even in the end of last year, and it had to be enacted from the second quarter of this year, according to the coalition agreement. Now the date when we plan to enact it is the 1st of October. In fact, we lost a year when there were no reforms in the civil service. We understand that without creating professional teams, we won't see any progress in the reforms. The general problem of all the draft laws is that you should not launch such laws around the entire bureaucratic procedure. Practically, it was ready and agreed in the Cabinet of Ministers with international organizations by the end of November last year. Yes, we think that it may have become better, but we still lost half a year, and you should create reformers teams in the government and everywhere. If we do not launch the reform this year and other reforms, then the chances for Ukraine to survive are really miserable. And the last thing I want to point out, there's a lot of argument with civil servants who say that we want to destroy the civil service. From the very start, we are for good salaries for civil servants, not less than in industry or elsewhere. But first, we should reach the level when the civil service works efficiently, when there's a result, when the economy of the country works, then the state will be able to raise the salary for civil servants. As Denis told you now, we are now planning to cut the numbers of civil servants, and this will provide the opportunity to raise the salary for those who retain their jobs. There's also a number of other draft laws that will reform the civil service as such, in general, and then we will do functional analysis and the optimization of different structures. The sooner this law is adopted in the way it is conceptually worked out, the better it is for the country and for the reforms in general.
Thank you, Ivan Hilobok, the National Reform Council. I would like to add a few comments on the process of preparation. The draft that was registered in the first reading received a positive assessment of Sigma program. That is the program which defines the principles of public administration in Europe. We received a letter from them in May. Also passing that draft is an indicator of getting by Ukraine of financial assistance from EU in the amount of 105 million, according to the contract of building up the state signed in May 2014. And that is why delaying the approval of that law will lead to Ukraine not getting this money or part of that money. Also on the process of preparation, the work was very efficient, very good, the work of the expert council, and that is who were preparing the main draft of the law. So the working group in the committee was very effective under the leadership of Aliona Shkrum. When experts, our international experts, started talking to MPs, many things would be explained, and the MPs, the civil servants, would perceive the concepts which are part of the draft law. So you shouldn't be afraid of any novelties. It's natural that the system resists changes, but we need to find the form of the dialogue and the mechanism that would explain to those who develop the decisions and those who make decisions. And these are MPs, so that we understand the format. The working group under the leadership of Aliona Shkrum, it has an advisory role. We had to analyze all these 1,500 amendments, all the positions of the MPs, but the decision on how will the draft look like depends on the committee whose first meeting will take place today. We all hope that this committee will allow to address some of the non-agreed on issues, and we hope that we will see today the ability of our Parliament to come to agreement, at least within one committee where there are representatives of different factions, and to reach a joint position which will change the country to the better, so that they can step away from their faction interests and make correct decisions. Thank you. Now Q&A session. If you have questions, you're welcome. Esteemed colleagues, do I understand it correctly? You say that Ukraine, one of the problems is prohibition to get involved into political activities. What are the obstacles? What will the key discussion be around at the committee today? I can start briefly. Today at the committee we will be discussing the categories of positions, political unbiasedness, and we mentioned about the political parties and political dependence, but also the scope of activities. The civil servants who work in the apparatus of authorities, they are civil servants, and they are covered by the law. The political positions which are appointed according to the quotas of the party, according to the submission of the President or Verkhovna Rada, they cannot be civil servants because they are not appointed according to the tender procedure. They have political responsibility. I'm talking about ministers, about Secretary of the National Security and Defense Council, any political position. They unfortunately are appointed according to the quotas of the party, and that is unfortunately is a constitutional provision. As soon as we get agreement on this issue, everything else will become much simpler. And the second one is categories of positions. We see that every state body requests some exceptions exceptions for themselves. That's probably normal. Every state body defends their civil servants. They request everyone to be in category A, so that even the advisors become the civil servants, even though they are not them. They're the patronage service, and they ask to upgrade them to category A. We explained that category is just a mechanism of distributing the responsibility and the mechanism of appointment, because category A is appointed according to the open competition by the single commission on civil service, and the category of A cannot include the political position which is not appointed according to the open competition. We also explained that categories have nothing to do with the payment, because payment is formed by 9 groups, and the payment is controlled not just by law but by the resolution of the Cabinet of Ministers. You cannot be in the category A, you cannot be appointed according to the national competition, and with that you can get very good salary, just the same as in category A if the position is similar. And that understanding is there already, but it's difficult to get it approved. When our Soviet system of ranks, Soviet system of civil service, they are still in our heads. And that is what we are trying to change, and I believe that we managed to do certain things. Any other questions?
Category A, of course, draws the most interesting discussion, but there is an inflation in our civil service of ranks 1, 2, 3. This is not really the issue of salary. This is the issue of access to cars, hospitals, and all this. What do you say about the mechanism of the implementation of this law? The ideology is in how this core of civil servants will be formed after the law is adopted, whether everybody will be dismissed and hired anew, or whether there will be a lot of competitions. To how will you form the core of civil servants? Why am I asking this? Because when we talk about the negotiations with the current civil servants, we see that they are concerned about their social status. In the work of your group, how do you see the influence of this law on the quality change of the civil servants? And so the second question is, there's a lot of issues in civil service that are being solved at the level of state enterprises. Where do you cut off the civil service in this respect? Where this is the lowest level? The second issue is simple. The second question, the law on civil service spreads to the bodies and apparatuses of the bodies of executive, bodies of power, and those that are being made equal legally to them. No enterprises, no institutions, no hospitals or anything else fall under the sphere of action of this law. This all remains in the labor legislation, and there's a code of laws on labor. And in principle, this law very clearly separates all this. More than this, there will be hired workers in this apparatus, those who do not have any authority where power is concerned, and who just perform service and functions. And of course there is a limit. For instance, IT people, administrators of information networks, where they will be classified. This is up to the Cabinet of Ministers to decide. they will make this more precise. Such, lines of discussion are still there. But as far as the first question is concerned, I'll tell you that there is a lot of issues that are going to be removed when everybody starts to understand this delineation between political offices and civil servants as such. All the benefits that you were mentioning as a rule, they belong to political offices. But in our legislation, the political offices were made equal with civil servants, and different benefits and statuses were applied to different civil servants, and then all the political offices wanted to become civil servants of respective ranks. If we understand that this is an absolutely erroneous way, then there are two parallel kinds of people, then everything falls into its slot, and the discussion is exhausted soon, I think. And about how we see the life after this law is adopted, first of all, we have a list of 26 normative regulations that we have to launch in order for this law to work. This is the mechanism of selection and general conditions for the work of this selection. And first thing that is going to happen, there will be a competition for state secretaries. This is going to be the start of the selection, and this competition won't be able, there won't be a possibility to appeal in the law, in the court against this decision. For instance, you haven't been selected, and then I go to the court and appeal against the decision. And we think that there will be an absolutely legitimate mechanisms. More than that, we think that ministers should be obliged to stick to the conditions of selection and competitiveness. They will be able to involve qualified specialists within, and to pay them more within the limits of the law. This is what the ministers lack now. We wanted this law to be adopted last year, before the new cabinet of ministers came into office. Unfortunately, this did not happen, and we think that this should have been done. Sorry, we are running out of time. Of course, there's a lot of other questions. Thank you for your honest talk. And I remind you that this discussion took place within the framework